Hello and welcome back to another episode of Courts This Week, your go-to source for the latest legal updates presented by LiveLaw. I'm your host, Syed Amir Hussain. I'm here to take you through and break down the most significant updates from this week. From the corridors of the Supreme Court to local judicial proceedings, I'll be providing you with clear and concise summaries that keep you informed and ahead of the curve. Remember, for a more in-depth understanding, do visit LiveLaw's website at www.livelaw.in. First, we'll take a look at the top headlines from this week, and then we'll dive into the details of each case. Let's get started. Won't change registered or notified waqfs, including waqfs by user during hearing. Centre tells Supreme Court on Waqf Amendment Act challenge. Urdu and Hindi, one language. According to scholars, language shouldn't become a cause for division. Supreme Court judges differ on action against AOR and advocate for misconduct in filing petition. Supreme Court criticizes Allahabad High Court for blaming victim in rape case. Form swift response protocols for road accident victims. Enforce drivers 8-hour daily work. Supreme Court to states and union territories. Supreme Court to consider practicing Muslim man's plea to be governed by Indian Succession Act instead of Shariat law. Supreme Court asks High Court committees to examine grievances regarding VC access to lawyers and litigants. Delhi High Court issues guidelines for prompt legal guidance to minor rape victims seeking medical termination of pregnancy. WhatsApp provides services in India to its users. Consumer complaint maintainable against it. UP State Commission. Senior advocate attacked in Bengaluru. Bar Council of India demands urgent protection for lawyers. Now, let's dive into the details of each update. The biggest headline from this week comes from the Supreme Court, which heard over 70 petitions challenging the controversial Waqf Amendment Act of 2025. The constitutional validity of the new law is under serious scrutiny, with prominent petitioners like AIMIM MP Asaduddin Owaisi, Congress MP Mohammad Javed, TMC's Mahua Moitra, the All India Muslim Personal Law Board and Jamiyat Ulema-e-Hind raising concerns. Interestingly, states such as Rajasthan, Gujarat, Haryana and Assam have intervened in support of the law, and the centre has filed a caveat. Senior advocate Kapil Sibbal opened arguments for the petitioners, while senior advocates Abhishek Manu Singhvi, CU Singh, Rajiv Shakdhar, Huzaifa Ahmadi and Sanjay Hegre and advocate Nizam Pasha supported Sibbal's contentions. The petitioners' lawyers argued that the Amendment Act was a grossly unconstitutional intrusion upon the rights of Muslims and the Muslim community secured under Articles 25 and 26 of the Constitution. They raised strong objections to several provisions of the amended law, particularly the requirement that a person must have practiced Islam for 5 years to create a waqf, the removal of statutory recognition for waqf by user under the Act, the inclusion of non-Muslims in the Central Waqf Council and State Waqf Boards, and a newly introduced provision that empowers a government officer to unilaterally determine whether a property is waqf. Crucially, under this provision, if the government lays claim to a property, it will be deemed not to be waqf until the officer's determination is made. On the other hand, Solicitor General Tushar Mehta staunchly defended the constitutionality of the law, asserting that the amendments were introduced to safeguard the rights of citizens whose private land had been wrongfully designated as waqf. He emphasized that the new provisions contain several salutary measures intended to bring clarity and accountability to waqf administration. On the first day of the hearing, the bench voiced serious concerns about the immediate and potentially irreversible impact of certain provisions, especially those affecting existing waqf properties like waqf by user, and indicated its inclination to grant a partial stay. However, on the Solicitor General's request, the matter was adjourned until the next day to allow the centre to make submissions regarding interim relief. The following day, the Solicitor General of India requested time to file a preliminary reply on the issue of interim relief. In the meantime, he offered significant assurances to the court. One, that no non-Muslim would be appointed to the Central Waqf Council or State Waqf Boards under the amended provisions, and that all registered or notified Waqfs, including those established by user, would remain undisturbed and not be denotified or altered in any manner. The court recorded the solicitor's assurances and listed the matter for further hearing on May 5th at 2 p.m. The case has now been officially renamed as in the matter of Waqf Amendment Act, and the court has designated 5 writ petitions, that is the ones filed by Asaduddin Owaisi, Arshad Madani, Muhammad Jamil Merchant, Muhammad Fazlur Rahim and Sheikh Nurul Hasan, as the lead cases in the challenge to the Waqf Amendment Act 2025. Meanwhile, public backlash against the act has intensified. On April 13th, violent protests in Murshidabad, West Bengal resulted in deaths of 3 individuals. 2 petitions have now been filed in the Supreme Court seeking a court-monitored probe into the violence. One plea demands an SIT under Supreme Court supervision, and the other seeks a 5-member judicial inquiry commission headed by a retired Supreme Court judge. Both petitions request the court to direct the West Bengal government to file a detailed report and take action against those inciting unrest. The Calcutta High Court has already intervened, ordering deployment of central forces to restore peace in the area. In a landmark judgment delivered this week, the Supreme Court dismissed a petition challenging the use of Urdu on the signboard of a municipal building in Maharashtra. The challenge was made to a Bombay High Court order which had upheld the display of Urdu on the new municipal council building in Patur, Akola district. The petitioner argued that this violated the Maharashtra Local Authorities Official Languages Act 2022, which mandates Marathi as the official language. However, the bench comprising Justices Sudhanshu Dhulia and K. Vinod Chandran held that the inclusion of Urdu on a signboard for the sake of effective communication did not violate the Act. Justice Dhulia, delivering the judgment, underscored the need to respect the linguistic diversity of India. He explained that Urdu is an Indo-Aryan language that evolved in India itself and cannot be treated as alien to the country. The court went further to say that language should not become a tool for division and highlighted how Urdu vocabulary is deeply embedded in day-to-day Hindi usage. The court also invoked the cultural heritage represented by Urdu, calling it an essential part of the Ganga Jamuni Tehzeeb, a composite cultural ethos that blends Hindu and Muslim traditions, especially in northern and central India. Referring to earlier decisions like the Uttar Pradesh Hindi Sahitya Sammelan versus State of Uttar Pradesh, the judgment reaffirmed the importance of safeguarding linguistic heritage. In the court's words, our strength can never be our weakness. Let us make friends with Urdu and every language. This week, the Supreme Court delivered a split verdict in a significant case concerning professional misconduct by an advocate on record and an assisting advocate who had filed a special leave petition while concealing material facts from the court. The case came to light after it was discovered that the second SLP had been filed to bypass an earlier order which directed the petitioner to surrender. The court had earlier noted this as a prima facie case of contempt but refrained from immediate punitive action after senior members of the bar urged leniency, pointing out that potentially devastating consequences on the careers of the advocates involved. In the verdict, Justice Bela M. Trivedi held that the AOR had filed applications without proper authorization and knowingly suppressed facts amounting to serious abuse of court process and a failure to provide honest legal advice. While she stopped short of initiating contempt proceedings or referring the matter to the Bar Council, she imposed penalties: suspension of the AOR from the register for 1 month and a fine of Rs 1 lakh on the assisting advocate, to be deposited with the SCORA for advocates' welfare. Justice Satish Chandra Sharma disagreed on the quantum of punishment, considering it excessive in light of the advocates' otherwise clean record. Accepting their unconditional apology, he opted for a cautionary approach, warning them against repeating such conduct. Due to this difference in opinion, the matter has now been referred to the Chief Justice of India for appropriate orders. The Supreme Court has come down heavily on the Allahabad High Court this week for making inappropriate and insensitive remarks while granting bail in a rape case. The case involved a college student who alleged that she had been raped by an acquaintance after she met him at a bar and later accompanied him to a relative's apartment because she was feeling unwell and intoxicated. There, she alleged she was raped twice. While granting bail to the accused, the Allahabad High Court observed that the victim had invited trouble herself and was responsible for what allegedly occurred. It further questioned her version by referring to her educational qualifications and stating that she was competent enough to understand the consequences of her actions. The Supreme Court expressed serious displeasure at these remarks. Justice B.R. Gavai asked why such comments were made at all, stating, "Granting bail is one thing, but why must a court make such comments?" He stressed the need for judges to exercise restraint and sensitivity, particularly in sexual violence cases, where such comments could add to the trauma and tarnish the dignity of the victim. Solicitor General Tushar Mehta also voiced concern, noting that in matters affecting public perception and victims' dignity, justice must not only be done but also seen to be done. Notably, the court is also dealing with another controversial ruling by the same High Court that had held certain acts such as grabbing the breasts of a minor and attempting to drag her under a culvert did not amount to attempt to rape. The matter has now been adjourned. This week, the Supreme Court directed all states and union territories to immediately take steps to develop swift emergency response protocols for road accident victims. The court observed that victims often suffer due to lack of timely medical attention or proper rescue, especially when they are trapped inside vehicles but not visibly injured. The bench of Justices Abhay S. Oak and Ujjal Bhuyan made it clear that such delays can be life-threatening and urgent. Structured intervention by local authorities is critical. While the applicant had suggested 6 specific points for setting up these protocols, the court chose not to issue a writ at this stage. Instead, it directed every state and union territory to come up with their own mechanisms suited to their local conditions. A 6-month deadline has been given to formulate these systems and file a response. The court also addressed the issue of driver fatigue, which is a major cause of road accidents, citing Section 91 of the Motor Vehicles Act and the Motor Transport Workers Rules. It reminded states that drivers of transport vehicles should not be made to work more than 8 hours a day or 48 hours a week. These rules, the court noted, are being routinely ignored. The Ministry of Road Transport and Highways has been directed to hold meetings with all states and union territories to discuss enforcement strategies. The court asked the ministry to consider introducing penalties to ensure better compliance. All states and union territory governments must submit their compliance reports by August end, and the ministry has been asked to consolidate these and report back to the court. This week, the Supreme Court agreed to consider a significant question raised by a practicing Muslim man, whether he can adopt to be governed by the Indian Succession Act 1925 instead of Muslim personal law or Shariat when it comes to inheritance and succession. The petitioner, Naushad KK, remains a practicing Muslim but seeks the right to be governed by secular inheritance law. A bench led by Chief Justice Sanjeev Khanna and Justice Sanjay Kumar took note of the matter, especially in light of another similar case, namely Sufia PM versus Union of India, where the petitioner had renounced Islam and sought applicability of the Indian Succession Act. Senior advocate Prashant Padmanabhan, appearing in the case, informed the court that although both matters in question the applicability of personal law, the facts are different. Unlike Sufia, Naushad continues to follow Islam. Another connected case by the Quran Sunnat Society that is pending since 2016 challenges Section 58 of the Indian Succession Act, which currently excludes Muslims from its purview unless they were married under the Special Marriage Act. In the Sufia PM matter, the union government has already submitted that bringing Muslims under the Succession Act is a legislative decision for the parliament. So far, the court has not taken a final view in any of these cases, but they could have wide implications on how inheritance laws apply to individuals from different faiths in India. In a decision with implications for digital access to justice, the Supreme Court this week disposed of a batch of petitions that had sought open access to virtual courtrooms links for all lawyers and litigants, even those whose cases are not listed for hearing on a given day. A bench of Justices Vikram Nath and Sandeep Mehta held that the issue falls within the realm of court administration and not the judicial domain. The main grievance of the petitioners was that many high courts restrict access to their video conferencing platforms, unlike the Supreme Court, which uses static links to open all with muted mic and camera. Several high courts block links to those not actively participating in cases. The petitioners argued this defeats the principle of open court hearings and violates the Supreme Court's 2018 judgment in Swapnil Tripathi, which allowed live streaming of court proceedings for transparency. They also highlighted the operational issues such as inaudible proceedings due to judges' microphones being muted and unnecessary denial of access despite the links being published in cause lists. The court, however, declined to issue directions, observing that the pandemic-era challenges that led to these petitions have since evolved. Justice Nath emphasized that such concerns must be addressed administratively and not by judicial fiat. The court gave liberty to the petitioners to approach the respective High Court and E-committees, including the Supreme Court E-Committee, NCMP and SCMS, for redressal. Taking serious note of delays in the medical termination of pregnancies in cases involving minor rape victims, the Delhi High Court had issued a comprehensive set of guidelines this week aimed at ensuring immediate legal and medical assistance. Justice Swarnkanta Sharma was dealing with the case of a 15-year-old rape survivor who had been denied termination services at LNJP Hospital due to the absence of a court order. Even though her pregnancy had advanced beyond 27 weeks, the court observed that hospitals continue to insist on prior judicial approval before referring the victim to a medical board. Even though previous orders had clarified that urgent situations must not be stalled by red tape. Expressing deep concern over this continuing practice, the court directed that whenever a minor rape survivor with pregnancy beyond 24 weeks is referred to a hospital, the Child Welfare Committee must immediately inform the Delhi High Court Legal Services Committee. The aim is to enable fast legal scrutiny, timely petitioning before the court, and an immediate medical board opinion without waiting for formal orders. The court further directed that medical boards must carry out assessments without delay and that LNJP Hospital must explain its 1-week delay in this case. Justice Sharma emphasized that intentions must be backed by actions, noting that systemic delays continue to undermine the rights and dignity of rape survivor. The hospital has been directed to proceed with the termination without delay, ensuring that the minor receives full medical care and respect throughout the process. In an important ruling on consumer rights in the digital age, the Uttar Pradesh State Consumer Disputes Redressal Commission has held that WhatsApp is subject to Indian consumer laws and that complaints against it are maintainable. Even though it's a foreign company, the case arose from a complaint by Amitabh Thakur, a former IPS officer and now president of Azad Adhikar Sena. He had approached the Consumer Forum in Lucknow after facing a 6-hour disruption in WhatsApp services, alleging that it interfered with his work and breached the platform's terms of service. His claim for compensation was rejected by the District Commission, which said WhatsApp was an international platform and that since Thakur hadn't paid any fees, he wasn't a consumer under the Indian law. The State Commission disagreed. It ruled that WhatsApp provides a communication service to attract users and is therefore a service provider operating in India. It categorically held that the platform cannot escape legal scrutiny merely by being headquartered outside the country. The Commission also found fault with the District Forum's interpretation of who qualifies as a consumer, calling it legally unsound. WhatsApp's free usage model does not shield it from consumer accountability. The Commission stressed it directed that Thakur's complaint be registered and disposed of within 90 days under the Consumer Protection Act, reaffirming that service disruptions on such widely used platforms are not beyond legal challenge. In a deeply disturbing incident this week, Senior Advocate and Co-Chairman of the Bar Council of India, Y.R. Sadashiva Reddy, was brutally attacked inside his professional chambers in Bengaluru. Two masked assailants barged in and assaulted him with iron rods, leaving him with fractures in right forearm, left elbow and leg. The attack took place in front of his junior and has been linked to an old grievance filed by a woman, which the Karnataka Bar Council had already resolved 2 years ago. Terming the assault as a premeditated act of intimidation, the BCI has issued a forceful condemnation and called for immediate action from both the central and state governments. It warned that such attacks are becoming increasingly common, especially targeting lawyers dealing with sensitive or high-stakes matters, including criminal trials and public interest litigation. The BCI said this trend is threatening not just individuals but the entire legal profession. And that's a wrap for this week's Legal News Roundup. But before we bid adieu, the entire team at LiveLaw has a request for its dedicated viewers. As an independent and fact-driven media organization, LiveLaw is deeply committed to fearless and ethical journalism and relies on its viewers' support to continue bringing you the latest legal updates, especially in this dynamic audio-visual format. So, here's how you can help. Give this video a thumbs up if you found it informative. Share it with your family, friends, classmates, and colleagues. Make sure you're subscribed to LiveLaw's YouTube channel for more insightful content. Drop your valuable thoughts and feedback in the comments section below. And hit that bell icon to stay updated with LiveLaw's latest releases. Don't forget to visit the LiveLaw website at www.livelaw.in for in-depth reports and analysis. Not only this, but the LiveLaw channel offers memberships for only ₹89 per month. You can become a part of LL supporters to access exclusive perks such as loyalty badges next to your name in comments and live chat, priority reply to comments, and for the student pass audience, early access to explainers and legal updates. I am your host, Sayyid Amir Hussain, and it's been a pleasure bringing you this week's Legal News Roundup. Until next time, stay informed, stay engaged, and stay tuned to LiveLaw. Thank you for watching.